Legal dictation start. Given him the notice in the prescribed form as required by Section 20, Subclause 2 of the Act, therefore the eviction petitions itself were not maintainable and therefore deserved to be rejected full stop. But the rent authority dismissed the same in both the petitioner's wide order dated 26/10/2018 full stop. However, since the petitioner tenant had also filed the written statements, therefore taking into consideration the pleadings of the parties, the rent authority framed the issues for its determination wide order dated 14/3/2019 full stop. Aggrieved against the above said two orders dismissing his applications for rejection of the eviction petitions passed by the rent authority, the petitioner's tenant filed two appeals before the appellate authority questioning the order passed by the rent authority full stop. Similarly, aggrieved against not ordering immediate eviction of the tenant and framing of issues in both the petitions, the respondent landlord also preferred two appeals before the rent authority full stop. Therefore, the appellate authority considered four appeals, two filed by the petitioner's tenant and two filed by the respondent landlord full stop. The appellate authority dismissed the appeals filed by the petitioner and held that the application for rejection of the eviction petitions had rightly been dismissed by the rent authority full stop. In the appeal filed by the respondent landlord, the appellate authority held that since the rent has not been paid by the tenant and the default continued even during the pendency of the proceedings before the rent authority, therefore the tenant was liable to be evicted for non-payment of rent full stop. Hence, the appeals filed by the landlord were allowed full stop. However, the matter was remanded to the rent authority to grant an opportunity to the petitioner tenant to pay the up-to-date rent to the respondent landlord, failing which the rent authority was directed to pass the eviction order without carrying out any further proceedings full stop. It is against these four orders passed in two different eviction petitions that the present four petitions have been filed by the petitioner tenant full stop. It deserves mentioned here that it is not even disputed the petitioner has not paid any rent after filing of the eviction petition before the rent authority full stop. Before the appellate authority also no rent was paid or deposited by the petitioner full stop. Before this court also the matter has been pending for about 2 years, but no rent has been paid to deposited by the petitioner full stop. Hence, during the pendency, the entire period full stop.